two major issues addressed by the recommendation. The first one is the issue of permissions. The concept of technical permissions cover the mechanisms traditionally present, allowing applications to access functionalities of resources of the phone, such as sensors or memory, and granting the permission allows to grant or to block access to resources regardless of the purposes pursued. So the OS provider requires to explain the application why access is requested. And permissions are at the heart of user protection. Purpose permission is not limited to giving or blocking access to a resource, but is intended to set the conditions under which a resource may be used for a specific purpose in the GDPR meaning. And so we have a lot of developments about permissions. And the relationships between consent management platforms, which make it possible to comply with the legal obligation and permissions, is sometimes, and I would say often, and maybe somewhat complex, and I will dwell maybe in the questions on this issue. The second, I would say, specific issue dealt with this recommendation is the relationships between privacy and competition, especially because we ask for a referral to the competition authority, the Autorité de la Concurrence, ADLC. This was the ultimate stage of a long-term cooperation between the two institutions, and it was not, because we wanted to act as in terms of policy action, but it was also because the sector of mobile phone, of mobile apps, is a specific competitive structure. You find the presence of vertically integrated actors along the value chain, and some of them are designated as gatekeepers in the DMA. And to a certain extent, it was, to a larger extent, it was successful relationships. And for instance, the competition authority warned us about the potential anti-competition issues or anti-competition action that our initial draft would have caused. So there is a systemic disclaimer within, at several points of the recommendation, stating that this recommendation is, of course, subject to competition law, and also meaning that there should not be any discrimination between actors, especially according to a market power of some of these actors. As regards the risk of self-preferencing and abuse of their position by operating system or application store providers, there are some observations on this issue regarding potential data collection during the application review process or in the provision of the operating system tools. The competition authority raised certain questions. In its opinion, the risk that permissions be implemented in a non-proportionate manner by OS providers, the risk that permissions be implemented in a discriminatory manner, in particular by not applying them to their own applications, because, of course, of this integration between within the OS providers' situation. The competition authority made several observations on good practices in order that some actors would not be tempted to favor their own apps and business interests. And so all these recommendations or opinions from the competition authority are reflected in the actual drafting of the recommendation.